Caveat and note, this is not legal advice. Seek adequate counsel knowledgeable in ICE, DHS, Border Patrol cases. It proves, however, a journalist explanation of some of the agency's involved process and procedures. As these constantly change, check as well, Federal Register, Code of Federal Regulations, agencies' websites, these may stretch the truth, periodicals such as Interpreter Releases, and other places such as Westlaw, Lexis and other computer, and online databases. Many Americans have now seen the brutal execution of American citizen, Renee Nicole Good, a 37-year-old mother and award-winning poet who was acting as a legal observer, with her death sparking widespread protests and debate over the actions of the federal agent, Jonathan Ross. They have heard how administration officials have described her as a domestic terrorist and, at least on the federal level, refused to investigate. This necessitates the discovery of the principal players, participant agencies in this sad American drama. The Department of Homeland Security, established in 2002, combining 22 different federal departments and agencies into a unified, integrated cabinet agency. It was born in the wake of the September 11th attacks. The Department of Homeland Security, DHS, is a U.S. government agency created to secure the nation from threats, manage border protection activities like customs, immigration, and anti-terrorism efforts. Its website says it works to keep the country safe from domestic and international risks. Thus, its mission remains to secure the nation from many threats. The agency encompasses numerous components like ICE, CBP, and TSA, coordinating across federal, state, local, and private partners to protect critical infrastructure and manage emergencies. Responding decisively to natural and man-made disasters is also with its mission. It forges partnerships to strengthen public, private, and international cooperation and crowdsourcing solutions. In addition to our underlying core values and guiding principles, 6 overarching Homeland Security missions comprise its core values under a motto: integrity, service before self, maintain the highest ethical and professional standards. Vigilance, guarding America, respect, honoring our partners with honor and integrity. We will safeguard the American people, our homeland, and our values. 5 guiding principles that shape the department's mission: keeping pace with our adversaries and preparing for those of tomorrow by identifying and confronting systemic risk, ensuring the nation's citizens remain resilient, building redundancy and resilience into community lifelines, and raising the baseline of our security across the board and across the world. In reducing the nation's risk to homeland security dangers, DHS mitigates risks to the homeland by interdicting threats, hardening assets to eliminate vulnerabilities, and enhancing rapid recovery efforts to reduce potential consequences from physical attacks and natural disasters. This is done also to promote citizen engagement and strengthen and expand trusted partnerships. Supposedly it is to uphold privacy, transparency, civil rights, and civil liberties. We don't see much of that anymore. However, it touts that DHS will continue to implement safeguards for privacy, transparency, civil rights, and civil liberties when developing and adopting policies and throughout the performance of its mission to ensure that Homeland Security programs uphold privacy, civil rights, and civil liberties. DHS proves an umbrella organization for other entities which ostensibly check our borders. Laws and regulations stem from a myriad of sources, including DHS rulemaking. The DHS mission activities ensure a homeland that is safe, secure, and resilient against terrorism and other potential threats. In many cases, DHS carries out its mission through regulatory actions. The DHS agenda includes regulations issued by DHS components, including among the following operational components with regulatory responsibilities: U.S. Citizenship and Immigration Services, USCIS, U.S. Customs and Border Protection, CBP, U.S. Immigration and Customs Enforcement, ICE. Legal authorities provide some of the major requirements for the federal rulemaking process. The Administrative Procedure Act, APA, 5U.S.C.551 governs the process by which federal agencies develop and issue regulations. The Regulatory Flexibility Act, RFA, 5 U.S.C. 601 ETSEQ, requires federal agencies, when developing proposed and final regulations, to consider the impact of regulations on small entities. Executive Order 13272, proper consideration of small entities in agency rulemaking, directs agencies to establish procedures and policies to promote compliance with the Regulatory Flexibility Act. Requires the Secretary, in coordination with the Secretary of State, the Attorney General, and the Director of the FBI, to establish a program through U.S. Customs and Border Protection, CBP, that seeks to prevent a child from departing the territory of the United States if a parent or guardian presents an order from a court of competent jurisdiction prohibiting the child's removal to a CBP officer. Accuracy for Adoptees Act, PUBL No. 113-74, this act amends the Immigration and Nationality Act, INA, to require that a certificate of citizenship or other federal document issued or requested to be amended under Section 320 of the INA reflect a child's name and date of birth as indicated on a state court order, birth certificate, certificate of foreign birth, certificate of birth abroad, or similar state vital records document issued by the child's U.S. state of residence after the child has been adopted or readopted in that state. Further, DHS issues guidance documents to help the public understand how DHS administers its statutory and regulatory authorities. DHS posts many of its guidance documents on the pages below. Generally, guidance documents lack the force and effect of law, except as authorized by law or as incorporated into a contract. But guidance documents help the public understand how U.S. Immigration and Customs Enforcement, ICE, administers its statutory and regulatory authorities. USCIS Manual, centralized online repository for USCIS immigration policies. And Administrative Appeals. The Administrative Appeals Office, AAO, conducts administrative review of U.S. citizenship and immigration services, USCIS, officers' decisions regarding immigration benefit requests in order to promote consistency and accuracy in the interpretation of immigration law and policy. Appeals has appellate jurisdiction over approximately 50 different types of immigration applications and petitions. A practice manual may also be found within. Closely correlative, we find the Border Patrol as part of the larger agency Department of Homeland Security, DHS. The Border Patrol proves a component of U.S. Customs and Border Protection, CBP. Within the CBP combines various border functions, customs, immigration, security, and agriculture, under one agency, with Border Patrol focusing on areas between official ports of entry, while CBP officers manage the ports themselves. It is the federal law enforcement arm of United States Customs and Border Protection. The U.S. Border Patrol, CBP, secures the nation's international land and coastal borders between official ports of entry, preventing illegal entry, smuggling, and terrorism. Ancillary duties include furnishing general assistance to the Customs Service in preventing the illegal importation of contraband and in assuming specific responsibilities in the prevention of illegal traffic in narcotics. Agents can be found in isolated communities throughout the United States. Traffic checkpoints. The Border Patrol conducts major highways traffic checks conducted leading away from the border to detect and apprehend individuals attempting to travel further into the interior of the United States after evading detection at the border and to detect illegal narcotics. The agency also effects transportation checks, inspections of interior-bound conveyances, which include buses, commercial aircraft, passenger, and freight trains. Among Border Patrol duties is to detect and prevent the illegal entry of individuals into the United States. Together with other law enforcement officers, the Border Patrol helps maintain borders that work, facilitating the flow of legal immigration and goods while preventing the illegal trafficking of people and contraband, and transportation checks, and anti-smuggling investigations. Immigration and Customs Enforcement. Under DHS supervision, we find immigration and border security through the Immigration and Customs Enforcement, ICE. Formed from parts of the former INS and U.S. Customs Service, ICE identifies, arrests, detains, and removes individuals in violation of immigration laws, managing detention and removals while also investigating transnational crimes. This federal law enforcement agency under the Department of Homeland Security, DHS, is the largest investigative agency under the DHS, with 4 operational directorates: Homeland Security Investigations, (SHI), the Principal Investigative Directorate, is responsible for investigating and acting against transnational criminal networks. Enforcement and Removal Operations, ARROW, enforces U.S. immigration law at, within, and beyond U.S. borders. The Office of the Principal Legal Advisor, OPLA, the exclusive representative of DHS in immigration removal proceedings, and Management and Administration, MNA, provides management services to above branches. ICE's primary mission promotes homeland security and public safety through criminal and civil enforcement of federal laws governing border control, customs, trade, and immigration. For instance, ICE will authorize the conduct of homeland security investigations or initiate the removal processes. ICE manages during the removal process, the detention and deportation of the person who violated the immigration laws. Thus, the Immigration and Nationality Act includes many provisions relates to the admission of aliens, the removal of aliens, grants of asylum, and the investigation of human trafficking. And correlative, the Federal Bureau of Investigation, the FBI, serves as America's primary federal investigative agency, blending intelligence gathering with law enforcement to address complex threats and enforce federal laws. The Domestic Intelligence and Security Service of the United States, serving as a federal law enforcement agency within the U.S. Department of Justice, responsible for investigating threats like terrorism, espionage, public corruption, civil rights violations, organized crime, white-collar crime, violent crime, and major offenders. The agency says its mission is to protect the American people and uphold the Constitution of the United States. Responsibilities include counterterrorism, protecting the U.S. from terrorist attacks, counterintelligence, combating foreign intelligence operations and espionage, civil rights, investigating violations of federal civil rights statutes, including hate crimes, criminal investigations, handling organized crime, white-collar crime, violent crime, and major offenders. Intelligence analysis, collecting, analyzing, and sharing intelligence to support its own operations and those of partners. The FBI's intelligence branch manages the FBI's intelligence strategy, resources, policies, and programs. The agency remains a member of the U.S. intelligence community, IC, a group of 17 federal agencies that collect intelligence. In addition to using intelligence to investigate and solve cases, the FBI shares it with other members of the IC who may be able to use the information. Private sector. Through the Office of Private Sector, the FBI regularly shares information with the U.S. private sector and educational institutions to help them stay ahead of threats and mitigate the risks posed by criminals, terrorists, and nation-state actors. Regardless of the intelligence gathering technique, the FBI supposedly follows all laws, policies, and procedures designed to protect the privacy of the American people. Intelligence collection is governed by the Attorney General's Guidelines and Procedures for National Security Investigations and Foreign Intelligence Collection, including the U.S. Constitution. Federal law established criminal procedures authorities controlled by U.S. courts, and as an agency of the U.S. Department of Justice and a member of the U.S. intelligence community, the FBI reports to the Attorney General and Director of National Intelligence. Lastly, what is known as a captured agency, in U.S. government-trained community organization terms, the U.S. Department of Justice, DOJ, is the federal executive department responsible for enforcing federal laws, ensuring justice, and keeping the country safe, acting as the government's lawyer to protect civil rights and uphold the rule of law through its vast network of agencies like the FBI, DIA, and U.S. attorneys. Headed by the Attorney General, it manages criminal prosecutions, civil suits, and provides law enforcement services, playing a key role in areas from counterterrorism to consumer protection. Opinion: it ostensibly abandoned most of that during the past year. The agency describes its Department of Justice mission as upholding the rule of law, to keep our country safe, and to protect civil rights. The DOJ website still alludes to the responsibilities through 6 litigating divisions, 5 law enforcement bureaus, and 94 U.S. attorneys' offices to uphold the rule of law, ensuring fair and impartial administration of justice. Enforce federal laws by overseeing the enforcement of all federal statutes. Protect civil rights by working to safeguard the rights of all citizens. National security, protecting against criminals, terrorism, and subversion. The Department of Justice continues to serve as counsel for the U.S. government. Its interfacing agencies in that matter include the Federal Bureau of Investigation, FBI, which investigates federal crimes. The Drug Enforcement Administration, DEA, which combats drug trafficking. Bureau of Prisons, BOP, which manages federal prisons. The U.S. Marshals Service, which protects federal judges, transports prisoners, and enforces federal warrants. U.S. Attorneys' offices, which prosecutes federal crimes in their districts. The Attorney General, a cabinet member who reports to the President, leads the DOJ. The Judiciary Act of 1789 created the Office of the Attorney General. Over the years, the head of the Department of Justice became the Chief Law Enforcement Officer of the federal government. In 1870, act that established the Department of Justice as an executive department of the government of the United States. Supposedly, the Attorney General represents the United States in legal matters generally, and the AG gives advice and opinions to the President and to the heads of the executive departments of the government when so requested. On occasion, the Attorney General appears in person before the Supreme Court. Also recently involved and drafted into immigration matters is the National Guard of various states, a descendant of the old colonies' militias. The National Guard remains a unique U.S. military reserve force with a dual mission, serving their state and the nation, acting as citizen soldiers and airmen, responding to domestic emergencies like natural disasters or civil unrest, and deploying overseas for federal missions alongside the Army or Air Force. Guard members can be called upon by their state governor or the President. Notwithstanding, the National Guard provides state responses in the homeland when disaster strikes, such as earthquakes, floods, and forest fires, or those human-caused, specifically focusing on ICE and arrests of American citizens, and others presumed to be foreign based on how they look or sound. Some laws authorize police to demand papers proving citizenship or immigration status from anyone they stop and suspect of being in the country unlawfully. In a footnote, one Supreme Court Justice Kavanaugh said that race and ethnicity could not be considerations when officers make immigration stops or arrests. The case did not concern stops. That directly conflicted with an earlier assertion that officers can use race and ethnicity as a factor when deciding whom to detain. With respect to criminal violations, there exists Homeland Security investigations, which can be seen lately with the SHE emblem. Still, ICE is divided into 2 main branches. While ARROW, Enforcement and Removal Operations, handles deportations, SHE, Homeland Security Investigations, functions more like the FBI. SHE special agents can legally arrest United States citizens if they have probable cause that the citizen committed a federal crime under its jurisdiction, such as human trafficking or drug smuggling. With respect to interference or assault, like any law enforcement officer, an ICE agent can arrest a United States citizen who physically interferes with an active investigation, obstructs an arrest, or assaults an officer. In these cases, the arrest is for a criminal offense, obstruction of justice, not for an immigration violation. More recently, though, we have seen SHE involved in immigration enforcement activities. If you are wrongfully detained in ICE custody through SHE, thereafter, act quickly. Know, be aware, protect, and focus on your rights. Although technically an American citizen doesn't have to show papers, if you don't want to spend a lot of time in detention, and if you have such, show citizenship proof, a passport if one has such, a birth certificate showing your United States citizenship if you have a lawyer, remain silent, limit statements until your status is verified by counsel. If not, request an attorney. When allowed, contact one who has ICE cases experience. Note the time, place, and agency, officer information. While it isn't right, we are now in the let me see your papers period of American existence. To lower repeat exposures, keep your citizenship papers or document copies, buttressed by your photo. For anyone, if ICE, SHE, Border Patrol law enforcement asks about my immigration status, stay calm. As possible, don't run, argue, resist, or obstruct the officer, even if you believe your rights are being violated. Keep your hands where police can see them. Don't lie about your status or provide false documents. If they request your immigration papers, you must show them if you have them with you. If an immigration agent asks if they can search you, you have the right to say no. Agents do not have the right to search you or your belongings without your consent or probable cause. They will often do so anyway, especially incident to a detention. If you're over 18, carry your papers with you at all times. If you don't have them, tell the officer that you want to remain silent or that you want to consult a lawyer before answering any questions. Prepare yourself and your family in case you are arrested. Memorize the phone numbers of your family and your lawyer. Make emergency plans if you have children or take medication. If you believe ICE wrongfully detained you or someone you love, keep your composure to avoid escalating the situation, although it appears lately ICE will strive to escalate it. This done by cursing, breaking car windows, pulling folks out of cars, throwing them to the ground to handcuff, placing knees on necks while doing so, even breaking into homes or places of business without a warrant. Lately, video has shown ICE behavior against the elderly, the handicapped, the disabled, including American citizens, adults, and teenagers. So your decision, but one can show proof of citizenship. Present a passport, birth certificate, or other documents verifying your United States citizenship. Remain silent, limit statements until a lawyer verifies your status. Request an attorney or contact one experienced with ICE cases immediately. Document details such as noting the time, place, and officer information for reference. If approached or stopped by ICE, and you are a United States citizen or legal permanent resident, legal experts and civil rights groups recommend the following thereafter or near the same time. If detained by a friend or relative, gather documentation, collect as much evidence as possible, proof of your citizenship or residency status, records of your detention, and any documents showing harm or damage, such as lost wages or medical records. ICE in or at courts. ICE has now begun arresting individuals who appear for scheduled interviews, including those seeking to adjust their immigration status, leading to justified fears that some check-ins were or are detention pretexts. ICE frames these mandatory check-ins as routine administrative procedures. In court appearances, oral opposition to dismissal template for pro-SE respondents from the National Immigration Project produced this template on May 30, 2025. Recently, the Department of Homeland Security, DHS, has been orally requesting dismissal of both represented and unrepresented non-citizens' removal proceedings in immigration court. Once the immigration judge grants dismissal, Immigration and Customs Enforcement, ICE, agents arrests the non-citizen in or around immigration court buildings with the goal of placing them in expedited removal. Again, expedited removal is a process through which ICE can detain someone without access to release under bond and deport a person without giving them a hearing in immigration court. This oral opposition to dismissal template for pro-SE respondents provides pro-SE, which means representing yourself, non-citizens guidance on how to oppose a DHS motion to dismiss. Here is one example of a pro-SE oral opposition to dismissal template. If the ICE attorney is trying to dismiss your case in immigration court, it is likely because ICE wants to put you in expedited removal instead, which allows them to deport you more quickly and without giving you have a hearing in immigration court. The oral motion opposes dismissal so that, if the immigration judge denies dismissal, you can continue to have your case heard in immigration court. Even if the immigration judge denies dismissal, ICE may still detain you. Therefore, it is important to make a plan with your loved ones in case you are detained, and to try to find an attorney if at all possible. In order to advocate with ICE on your behalf, the attorney you hire now or in the future will need a G28 form signed in ink. If you do not go to a scheduled court hearing, you may receive an in absentia deportation order, which may lead to ICE to detain you at home or elsewhere and deport you very quickly. This motion is a template, meaning that it does not reflect the specific facts of your case. You must figure out which of the highlighted portions apply to you, if any, and only say the ones that make sense for your case. If you can't figure out which ones would apply to you, do not use the highlighted ones. Portions at all. You may need to tell the IJ that you want to make an oral opposition. After the ICE attorney states their intent to dismiss the case, if the IJ does not ask you your position, you will need to say, "Your Honor, I oppose dismissal and would like to state the reasons why I oppose, and Your Honor should not dismiss my case." The oral opposition is designed to be a template to help you determine what to say out loud in court, not a document to be filed. You should not submit the opposition template to the court or to ICE. Remember to preserve appeal if the IJ grants dismissal. This is important whether or not the immigration judge gives you the opportunity to make your oral opposition. The immigration judge's refusal to let you opposing the dismissal could be grounds for appeal. Below are some tactics that can be used to attempt to thwart ICE trickery, so as not to directly conflict with equal protection principles and reinforce the importance that immigration enforcement must respect constitutional boundaries, especially in encounters that risk detention, racial profiling, or undue coercion. The federal government's litigation against state immigration protections. The government has challenged the Court Access Safety and Participation Act, CASPA, which prohibits civil arrests in and around state courthouses. The complaint alleged that CASPA unlawfully regulates federal officers and impedes federal enforcement operations by restricting where arrests may occur, even though courthouse arrests often enhance public safety. CASPA is not interfering with federal immigration law. The act is a neutral measure that seeks to protect the integrity of state judicial proceedings and ensure that litigants, victims, and witnesses can safely access state courts. Thus, more special information for United States citizens: if ICE arrests, detains you or a beloved, currently held, indicate that you are a United States citizen. I am a United States citizen. You have no legal authority to detain me. You may get struck, maced, pepper sprayed. But you document you have told them. Immediately demand to speak with an ICE field office director or supervisor to present your proof of citizenship. Not that it will do much good with some ICE people. Where prolonged detention and you have counsel, a filed petition for writ of habeas corpus in federal court is a requisite. Normally, this requires the government agency or entity to substantiate your detention before a federal court judge. The writ of habeas corpus, you have the body, demands a prisoner be brought to court, or a writ of execution to seize property. It remains a fundamental legal order compelling authorities to bring a detained person before a court to determine if their imprisonment or detention is lawful, and acts as a crucial check against illegal or arbitrary confinement by the government. A writ, a powerful court directive, is a formal, written order from a court or other legal authority commanding someone, a person, agency, or lower court, to perform or stop performing a specific action, ensuring laws are followed and judicial decisions respected. Writs enforce rights, provide remedies, and ensure judicial power isn't abused. They allow for judicial review of agency actions or lower court rulings. As an official document, it is a formal order. It is not a request. It directs someone to do or not do something. Habeas corpus, known as the Great Writ, protects individual liberty by requiring the government to justify holding someone, allowing challenges to unlawful detention, demanding a person be brought before a court to determine if their detention is lawful, unconstitutional sentences, or violations of rights, even after direct appeals. The writ is used to review the legality of a person's detention, ensuring they aren't held without legal justification or due process. It is often used as a last resort after regular appeals, used to raise new evidence or claims of constitutional violations. The constitutional basis for the writ as protected by the U.S. Constitution, Article I, Section 9, again, it is a safeguard against tyranny, ensuring people aren't locked up arbitrarily. Present common uses seeks release from unlawful confinement, and challenging the detention of immigrants. However, know that certain criminal convictions, involvement in immigration fraud, or being deemed a threat to national security are among the reasons some are being held, often in pretext. According to one government website, while in custody, ICE remains legally required to follow strict detention standards that govern medical care, safety, and access to legal counsel. Don't count on it. But unlike U.S. citizens, permanent green card holders, LPRs might face mandatory detention without bond for specific offenses, though due process requires they generally maintain the right to a hearing before an immigration judge. Criminal grounds for LPRs and green card holders can include detention for aggravated felonies, crimes of moral turpitude, or drug-related offenses. For certain crimes, federal law requires mandatory detention that ICE hold the individual without the possibility of release on bond during their removal proceedings. Where re-entry risks might be found, permanent residents returning from abroad can be detained at the border if they have been outside the U.S. for more than 180 days. So too, if they have a disqualifying criminal record. While ICE has the authority to detain, LPRs maintain due process rights, and are protected by the Constitution, and typically cannot be deported without a formal hearing and a judicial order. Or the websites declare, over the past year, this has been ignored on occasion. More explicitly, legal detention grounds and primary conditions whereby a permanent resident is held involve violations of immigration law. For a person having lived in the U.S. for many years, a single conviction for an aggravated felony might trigger immediate detention. And if ICE believes a green card holder obtained their green card through fraud or if suspected of involvement in terrorist activities, they may be held as a matter of national security. Detention is managed by ICE through either local jails, federal facilities, or contracts with private prisons. Held in error, these must be released quickly. However, ICE continually breaks the law on how quickly citizens are turned loose. And ICE officers may temporarily detain someone if they believe that the person may not be a citizen. And in some cases, even recently, ICE has wrongfully deported United States citizens. Detaining a U.S. citizen remains unlawful. ICE can hold someone until it can confirm the individual's citizenship status. And the agency or employee has been known to take its time doing so. Listen to the remedies described in ICE Skates SAD, Part 2 and Part 3. Most American citizens will never face ICE detention, but wrongful detentions remain a real possibility. Between 2003 and 2019, studies documented hundreds of cases where ICE detained or even attempted to deport U.S. citizens, or did so. But if ICE officers stop you, knowing your rights can help you respond safely and effectively. Here is what to do if ICE stops you and you are a citizen. The fundamental constitutional protections of due process and equal protection embodied in our Constitution and Bill of Rights apply to every person, regardless of immigration status. Even as an undocumented immigrant, these ones have just by being present in the United States, the right to due process, the right to legal representation, the right against unreasonable search and seizure, the right to not be arrested or detained without a valid reason, the right to record interactions with law enforcement. Knowing your rights and protections under the Constitution is the first line of defense. Learn more about what to do during encounters with immigration enforcement agents. Further, people fleeing persecution and violence have the legal and human right to seek asylum in the United States. This is now continually being denied, or roadblocks placed, making it much harder to effect. In situations outside of immigration, for example, a local officer is accompanying an ICE or Border Patrol person in some states, you must provide your name to law enforcement if you are stopped and told to identify yourself. But even if you give your name, you don't have to answer other questions. If you are driving and are pulled over, the officer can require you to show your license, vehicle registration, and proof of insurance, but you don't have to answer questions about your immigration status. Customs officers can ask about your immigration status when entering or leaving the country. If you are a lawful permanent resident, LPR, who has maintained your status, you only have to answer questions establishing your identity and permanent residency. Refusal to answer other questions will likely cause a delay, but officials may not deny you entry into the United States for failure to answer other questions. But oftentimes, they now do so, it appears, unlawfully. If you are a non-citizen visa holder, you may be denied entry into the United States if you refuse to answer officers' questions. Still, you have the right to remain silent and do not have to discuss your immigration or citizenship status with police, immigration agents, or other officials. Anything you tell an officer can later be used against you in immigration court. If you are not a United States citizen and an immigration agent grabs through wrongful detention, mistakes, this occurs when ICE mistakes a United States citizen or green card holder for someone who is in the country unlawfully. These mistakes may stem from outdated records, administrative errors, or misidentification. Regardless of the cause, wrongful detention is a violation of your constitutional rights. When this happens, you may be eligible for compensation for the harm you've suffered, including emotional distress, lost wages, reputation damage, and more. Listen to the Federal Tort Claims Act in ICE Case SAD, Part 3. It is said that the most common way United States citizens end up in ICE custody is through administrative errors. This often happens also due to outdated databases. Federal records may not have been updated to reflect that a person naturalized. You have the right to remain silent, present proof of citizenship, and request legal representation. Beyond knowing your rights, taking immediate action can sometimes. You might ask why ICE is detaining you and if you are free to leave. If ICE lacks the legal right to keep you there, you can walk away. These days, sometimes you are violently restrained, even if you have that right or try to exercise it. Do not sign documents without consulting a lawyer. ICE paperwork may involve agreeing to give up legal rights or to leave the country. Again, clearly state that you are a U.S. citizen and provide proof if available. Request an attorney immediately, if you have one. An immigration lawyer can contact ICE supervisors, provide supporting documents, and, if needed, file a court request to challenge unlawful detention or notify federal authorities to secure your release. If possible, inform loved ones. They might be able to bring documentation to prove your citizenship, coordinate finding a lawyer, and notify local or federal officials to support your claim. If they are allowed in or on the premises where you are being held. Unfortunately, in many cases, ICE officers may still keep someone in custody until someone brings proof of their citizenship, such as a birth certificate or passport, or an attorney intervenes. The case of green card holder ICE detention versus U.S. citizen detention. ICE has the authority to deport lawful permanent residents, LPRs, when they violate certain immigration laws. This means ICE has the authority to detain LPRs, and securing their release can be more complicated. In contrast, ICE does not have the authority to detain U.S. citizens. A U.S. citizen detained by ICE should be promptly released. When the agency holds a citizen, it always acts by mistake and must correct the error. Oftentimes they do not. So here, one has the right to sue, after filing a prior administrative claim, and waiting 6 months to respond. There now exists ICE and Border Patrol monitors on the agency's whereabouts in a place. Know that recording ICE or Border Patrol is not unlawful, nor is following them, although they may unlawfully detain one just to put them through the hassle of detention and later going to court, most likely with the result of the case being thrown out. Again, while not an immediate remedy, the Federal Tort Claims Act will offer some compensation, but not against the ICE or Border Patrol person, but still successfully against another entity. Many reports show ICE detaining people who are following them, recording them, and monitoring their activity. Remember, it is not illegal to follow or film an ICE agent, but if you do so, you should do so from a safe distance and avoid interfering with ICE operations. Courts have ruled it is permissible, and recording or following does not impede nor obstruct the agencies, if done at a distance. Numerous federal appeals courts have consistently held that the First Amendment protects the right to record law enforcement officers, including ICE, when they are performing their duties in public. Although DHS has, in fact, adopted a policy that appears to violate the Administrative Procedure Act, plaintiffs have plausibly and sufficiently alleged a decision to adopt a policy with regard to how DHS treats the recording of its agents, one court noted. In addition, every federal circuit court of appeals that has addressed this issue has held that there is a First Amendment right to record police activity in public, according to a 2017 ruling from the Third Circuit Court of Appeals. But DHS attorneys argued observers do not have First Amendment rights to peacefully follow law enforcement in the current environment because they are summoning crowds of antagonists who eventually impact ICE operations. An agent snatched the phone out of a woman's hand as she was recording ICE agents during a traffic stop. The agent seemed to be accusing her of illegally following them. Following is not a crime, and the courts indicated it remains well in the rights of an American citizen. Still, those doing so might be put through the ringer of a trial and having the case dismissed, and then sue under the Federal Tort Claims Act. When Americans operate their cars lawfully on public roads, that's not a basis for ICE to effect a traffic stop or point guns at anyone or use force against them. They haven't committed any crimes. One court held, your rights if you are approached by ICE at your home, don't open the door unless ICE presents a valid judicial warrant signed by a judge. Most ICE warrants are administrative and do not allow them to enter your home without permission. A valid judicial warrant contains 1. Names a person in your residence and / or what specific areas are to be searched at your residence, and 2. Is signed by a judge, must be a judge who is not an immigration judge. An administrative warrant is signed by an ICE officer. Ask ICE to slide the warrant under the door for you to review. Do not open the door to receive the warrant. If an ICE agent enters your home without your permission or a valid judicial warrant, do not physically resist, as that could subject you to potential criminal charges. But make it clear that you did not provide consent. If ICE begins to search your home, make it clear that you do not consent to the search. You do have a right to remain silent or state clearly, I am exercising my right to remain silent. If you do not remain silent, do not lie to ICE agents, as that may impact you in the future. Record the interaction if it is safe to do so, or ask someone else to record it. If you record, do not interfere with the ICE operation. If you are approached by ICE at work, know that ICE can enter the public space of any workplace without any type of warrant. Public spaces can include an office lobby, a supermarket, a retail store, or a dining area of a restaurant. ICE cannot legally enter the private space of a workplace unless they have the permission of your employer or a judicial warrant. Private spaces include employee-only areas. If approached, do not panic. Stay calm and avoid running or making sudden movements. Ask if you are free to leave. If yes, calmly walk away. If you are not free to leave, ask if you are being detained. If you are being detained, you do not have to answer any questions. You always have the right to remain silent. If you are asked about another person's identification or for information pertaining to another person's whereabouts, you do not have to answer those questions. If you are being detained, you must show a form of identification. You can use your non-expired state-issued ID or tribal ID to show your United States citizenship. If an ICE agent does not accept your tribal ID, request to speak with their supervisor. Not all ICE agents are aware that a tribal ID is a legal form of identification in the United States. Do not sign anything without consulting an attorney. If it is safe to do so, record the interaction or ask someone else to record it. Do not interfere with the operation. If you are approached by ICE in public, know that ICE can enter public spaces without any type of warrant. Public spaces include an office lobby, a supermarket, retail store, or dining area of a restaurant. If approached, do not panic. Stay calm and avoid running or making sudden movements. Ask if you are free to leave. If yes, calmly walk away. If you are not free to leave, ask if you are being detained. If you are being detained, you do not have to answer any questions. You always have the right to remain silent. If you are being detained, you must show a form of identification. You can use your non-expired state-issued ID or tribal ID to show your United States citizenship. If an ICE agent does not accept your tribal ID, request to speak with their supervisor. Not all ICE agents are aware that a tribal ID is a legal form of identification in the United States. If it is safe to do so, record the interaction or ask someone else to record it. Do not interfere with the operation. If you are approached by ICE in your car, many reports exist of ICE stopping cars or ICE approaching people. Know you have the right to remain silent. Never lie to an ICE agent. You can ask if you are being detained. If not, ask if you are free to go. If you are free to go, calmly drive away. ICE agents sometimes stop cars or approach cars based on a person's perceived ethnicity. In many states, you must pull over if you are stopped by any type of law enforcement officer, even if you do not think you did anything wrong. Because ICE agents sometimes use unmarked cars or wear plain clothes or clothes that say police, you may not know they are ICE when they approach you. If you cannot tell, you are allowed to ask the individual who they are and for their identification. You are only required to roll down your window if an officer asks you to. If you are asked to, roll down your window to allow for clear communication. Be aware that there are many instances of ICE agents opening car doors or breaking windows. If an ICE agent asks for your ID, and you are the driver, you are required to show your driver's license. If an ICE agent asks for your ID and you are a passenger, you do not have to show your ID or provide any personal information. However, ICE may still detain you to determine your citizenship status, so it may be safest to show your identification or proof of citizenship. If an ICE agent asks you to get out of the car, before you get out, you should ask for a reason why you were stopped and ask the ICE agent to identify themselves. Remember, ICE generally cannot search your car or your person without a valid judicial warrant. If ICE searches your car without a warrant, you should tell them you do not consent to the search. If you are approached by ICE and you are a minor, know that minors have the same protections as adults. They have the right to remain silent and not answer questions about their immigration status, where they were born, their parents' immigration status, their address. A simple response like, "I choose to remain silent. I want to speak to a lawyer," is enough and protected by law. Minors are not legally required to carry identification unless operating a vehicle. Carrying a copy of your tribal ID, passport, birth certificate, or legal residency document should be done only if necessary and with safeguards. Example, in a sealed envelope labeled confidential, legal documents access only by guardian. If you or your parent are detained, you have the right to be near and in touch with your parent. If you are detained by ICE, try to stay calm. You have the right to remain silent. You have the right to consult with a lawyer. If you choose to remain silent, clearly state, "I wish to remain silent," and ask for a lawyer. You can tell ICE you have medical issues or need to arrange for child care. Not that they will abide by it, but your informing them is enough for the later FTCA case. Of course they will deny. If ICE agents do not speak your language, you can request an interpreter for any conversation with ICE. If you are being detained, you must show a form of identification. If you are a United States citizen, you should say, "I am a United States citizen," and ask why you are being detained. You can use your non-expired state-issued ID or tribal ID to show your United States citizenship. If an ICE agent does not accept your tribal ID, request to speak with their supervisor. Not all ICE agents are aware that a tribal ID is a legal form of identification in the United States. Do not say anything, sign anything, or make any decisions without consulting a lawyer. Once detained, you have the right to make phone calls to family, friends, or a lawyer. ICE, DHS, Border Patrol might not allow this for days. If you are in detention, you supposedly can receive visitors, including family, friends, and lawyers, depending on specific detention facility rules. You can request a list of free or low-cost legal service providers to seek representation, not that they will allow it. Native Americans who believe ICE violated their rights call the Native American Rights Fund at 303-447-8760. If arrested by police, not ICE, you have the right to a government-appointed lawyer for criminal proceedings only. If you believe you are at risk for a potential ICE detention, if you believe you may be at risk for an ICE detainment, it may be helpful to create a safety plan. A safety plan should include of identifying your emergency contacts and memorizing their phone numbers. Provide your child's school or daycare with an emergency contact to pick up your child. Keeping your important papers, like birth certificates, medical records, and children's medical records, in a safe place and telling a loved one where you put those papers. It may be helpful to keep a copy/photo of your birth certificate or proof of citizenship with you. Written authorization for an emergency contact to make medical and legal decisions for your child. Protecting your rights against wrongful ICE detention. ICE can be indiscriminate. ICE cannot legally hold a United States citizen overnight, especially if the United States citizen gives ICE verifiable proof of their citizenship. ICE does not have legal authority to detain United States citizens. They do so anyway. Release time varies, once you provide evidence of citizenship. Some people are released within hours, while others remain detained for days if ICE delays verification. Attorneys for the detained oftentimes speeds up the process. If ICE detains you and you fear returning to your country of citizenship, tell ICE if it arrests you and attempts to deport you through expedited removal. But if you fear returning to your country of citizenship, you will need to say that you are afraid of going back and request a credible fear or reasonable fear interview. Do not wait to be asked about your fear. Oral opposition to dismissal template for pro se respondents. Your Honor, before you dismiss my case, the law requires you to consider my arguments against dismissing my case. Only the court has the power and the duty to decide which cases are dismissed, and the court should decide my case on the merits. If you dismiss my case, I will be prejudiced because I will not have the opportunity to present my application for relief and the evidence that I have in support of my application, which is my right under the law. Also, if you dismiss my case, DHS may put me in expedited removal and deport me very quickly, which makes the potential harm in my case even greater than usual. If applying for asylum, withholding of removal, or CAT, or if you fear return, I face persecution, torture, and death in my country of citizenship, and I must have an opportunity to seek protection here in the United States. If applying for cancellation of removal, my United States citizen/lawful permanent resident spouse/parent/child would suffer exceptional and extremely unusual hardship if I were deported, and I would lose my ability to stay with and care for my family. I will not have the opportunity to apply for cancellation of removal if this case is dismissed and I am in an expedited removal process. If applying for another form of relief, describe harm in denying the opportunity to apply, it was the Department of Homeland Security's choice to put me into these removal proceedings before Your Honor, and they do not have a legal basis for putting me into expedited removal instead. It is also unlawful for DHS to apply its January 24, 2025, expedited removal expansion memo to me retroactively. If you have lived in the United States for more than 2 years, I have lived in the United States since X date, more than 2 years, and I do not think that expedited removal should apply to me. Additionally, because DHS has not proven what the regulations that control dismissing a case require, the court should not dismiss my case. DHS has to prove that the circumstances in my case have changed since DHS chose to place me in removal proceedings. DHS also has to prove that the changes circumstances now mean that it is in DHS's best interest to ask Your Honor to dismiss my case. Circumstances have not changed in my case, and DHS cannot prove that it is now in the department's interest in dismissing my case, especially since putting me in expedited removal would mean starting an entirely new process. DHS's request to dismiss my case is unlawful and would prejudice my case and harm me. I respectfully request that you deny DHS's motion and instead consider my case on its merits. If IJ grants dismissal, I reserve my right to appeal the court's decision. Your Honor, please note on the record that I reserved an appeal and that the dismissal order cannot be executed while my appeal is pending. For non-profits and other quasi-public spaces, police and ICE can enter public areas without permission, but police and ICE can't enter private areas in your non-profit without a judicial warrant or your permission. Although ICE agents may present an administrative warrant, that is not the same as a judicial warrant and does not permit ICE to enter private areas without permission. A valid judicial warrant is signed by a judge and specifically describes the area ICE is permitted to search. You have the power to designate public and private areas of your nonprofit or business. Generally, a public area is somewhere where members of the general public may come and go freely. Public spaces are those where people do not have an expectation of privacy, and private places are where people do expect privacy. The Constitution's expectation of privacy can be affected how the space is used. Example: private homes, sleeping quarters, bathrooms, medical examination rooms, or places where sensitive personal information is stored or shared. Create private areas through the use of locked doors, opaque window dressings, and clear signage. Signs might include language such as private property, entry by appointment only, patients and staff only, or no entry without authorization. You can and should enforce your signs and private spaces. If a nonprofit or entity marks an area no entry without authorization, the nonprofit or entity must enforce that policy against everyone. Policies can protect your private spaces by empowering your employees to deny entry to police and ICE agents without a judicial warrant. Set policies that specifies who is empowered to allow access to your building and to whom access is allowed. Instruct staff that they do not have authority to grant access to a building or private area, allowing them to explain to police or ICE agents, "I can't permit you to enter. You must speak with my employer." If you prepare your staff and facility to respond if police or ICE agents seek to enter your buildings, designate a person empowered to engage with police or ICE agents at the minimum level, so that other staff know who to contact. Staff are not required to answer questions about their co-workers or their clients. If you are arrested by regular police, you have the right to a government-appointed lawyer. If you are detained by ICE, you have the right to consult with counsel, but the government is not required to provide one for you. You do not have to answer questions about where you were born, whether you are a United States citizen, or how you entered the country. At international borders and airports, separate rules apply. This is so for individuals on certain non-immigrant visas, including tourists and business travelers. Again, if arrested or detained, say you wish to remain silent and ask for a lawyer immediately. Again, you do not get a free one in immigration proceedings, unless it is a criminal matter. Don't give explanations or excuses. Don't say anything, sign anything, or make any decisions without counsel. If you have been arrested by police, you have the right to make a local phone call. The police cannot listen if you call a lawyer. Not really observed, although should be, by ICE, DHS, Border Patrol, and other such agencies. If you have been detained by ICE, you have the right to contact your consulate or to have an officer inform the consulate of your detention. Remember your immigration number, a number, and give it to your family. It will help family members locate you. Keep a copy of your immigration documents with someone you trust. If you are a non-citizen, ask counsel if you have such about the effect of a criminal conviction or plea on your immigration status. Do not discuss your immigration status with anyone but your lawyer. While you are in jail, an immigration agent may visit you, supposedly. These visits are curtailed in some centers. Do not answer questions or sign anything before talking to a lawyer. Read all papers fully. If you do not understand or cannot read the papers, tell the officer you need an interpreter. With regular law enforcement, if you believe your rights were violated, document everything you remember, including officers' badges and patrol car numbers, which agency the officers were from, and any other details. Get contact information for witnesses. If you're injured, seek medical attention immediately and take photographs of your injuries. One can file a written complaint with the agency's Internal Affairs Division or Civilian Complaint Board. In most cases, you can file a complaint anonymously if you wish, often to no avail. In recent years, immigration detentions exhibit little to no regulations or enforceable standards regarding conditions. This includes lack of medical treatment, mental health care, religious services, transfers, and access to telephones, free legal services, and legal library materials. Usually most detainees don't get legal representation. This makes it more difficult not only to succeed in immigration proceedings. They also can't complain regarding substandard treatment. Family detention. Most Central American families detained by DHS came to the United States seeking refugee protection. They have fled a dangerous world area where women and children are raped, abused, and killed without consequence. 88% of detained families have demonstrated to a DHS asylum officer that they have a credible fear of persecution if deported. DHS's policies of detaining families seeking asylum push to deter future migration from Central America. Recently, the court blocked DHS from relying on general deterrence as a basis to detain families. Private companies' immigration detention to manage the growing detainee population, ICE turns to contracted facilities, example for-profit prison corporations and county jails. Contract facilities run by for-profit prison corporations operate outside the purview of public oversight and accountability. With no one to hold them accountable, private companies move to cut medical staffing and deny care to maximize shareholder return, resulting in rampant detainee abuse and neglect. Medical neglect at ICE detention facilities proliferate. ICE detention center violates immigrants' rights and basic needs. ICE and the Department of Homeland Security fail in giving proper treatment for basic human needs for the immigrants in their care. Plaintiffs in a recent lawsuit cite excessively restrictive and punitive conditions. For example, being placed in solitary confinement for requesting to finish showering. People with disabilities are denied basic accommodations, such as sign language interpreters and wheelchairs. Invisible to public scrutiny, that which happens in a detention center behind barbed wire and locked doors. Detainees describe punitive treatment and harsh conditions. A facility might hold people in small concrete cells for hours with inadequate clothing, food, or water. Immigrants are oftentimes denied basic medical care, disability accommodations, and lawyers and beloved access. Officers threaten those who speak out against the abusive conditions with violence and solitary confinement, used excessively. Some detained immigrants fight back. Pervasive fear and suffering have driven others to abandon their legal rights and agree to deportation. Further, immigration detention without a constitutionally adequate bond hearing in which the government bears the burden of showing that detention is necessary to protect against danger to the community or flight risk infringes on due process rights. Sadly, more than half of individuals in immigration court proceedings are currently unrepresented, including 84% of those detained. More comprehensively, what one does when immigration officials detain someone. Steps 1. Ask your friend/family member for their A number, a hashtag. This number usually contains 9 digits. ICE will give them this number upon arrest. If your friend/family member filed a previous immigration application, it's likely they will already have an A hashtag on any documents from immigration. If your friend/family member was arrested at the border and allowed to enter, it's likely they will already have an A hashtag in their immigration documents. 2. Locating someone in detention. Use this link to locate your friend/family member if they have been detained by ICE. https://locator.ice.gov/odls/number/search. Search by either a hashtag and country of birth, or person's biographical information. ICE has information, including location and contact information, for the detention centers it uses on its website, https://www.ice.gov/detention-facilities. 3. Communication/visits. Once you locate your friend/family member using the link above, you may contact the detention facility to schedule calls or visits. Some facilities allow for in-person visitation, while others may provide for video visitation only. Each facility has its own process for setting up phone accounts so that your friend/family member can call you. You should contact the facility to ask about setting up a phone account for your loved one. Similarly, call the facility for information on how to send your loved one money if you want them to have funds to purchase basic necessities or food at the detention center. 4. Report any raids. Write down details about what happened as soon as possible. 5. Gather immigration and criminal documents if any. Collect any prior immigration application filed and receive notice. Collect police reports, probable cause affidavits, charging documents, and sentencing documents. 6. Locating immigration court hearing information using the A hashtag. You can look up their next immigration court hearing using this link, https://acis.eoir.justice.gov/n, or call 1-800-898-7180. Note: the following people do not have a right to a court hearing and may be deported without going before a judge, including outstanding removal orders. A judge previously ordered someone removed. For example, they missed court, lost their immigration case, or were not eligible for a court hearing. ICE can remove them with the old removal order unless the non-citizen files a successful motion to reopen their immigration case. Sometimes immigrants have no knowledge. No removal order has reached them. Prior deportations, ICE is able to remove people who were previously deported, including people deported in expedited proceedings at the border, without the right to a court hearing. Check for outstanding removal orders and prior deportations by an immigration judge on the Immigration Court portal. Aggravated felony offenses. People who have been convicted of offenses that are considered aggravated felonies under immigration law, and those who also do not have lawful status, may be removed from the U.S. without a hearing. For prior deportations and aggravated felony convictions, if someone expresses a fear of returning to their country, they will have a reasonable fear interview, RFI, with an asylum officer. If they pass the RFI, then they will have hearings before an immigration judge to seek protection based on their fear. If you are afraid, tell every immigration official you meet. Expedited removal orders. Non-citizens who are apprehended at or near the border may be removed by an expedited removal order. They only get a hearing if they express a fear of returning to their country of origin and pass a credible fear interview, CFI, with an asylum officer. Important: ICE tries to apply expedited removal to more people. This is true where even those who already had a court hearing or who have been in the United States for a long time. If this happens, follow the expedited removal guidance above. If this happens at a court hearing, inform the judge you oppose dismissal of your case. Example of a verbal pleading. ICE has started making arrests at immigration courts countrywide. In one of the ICE Skate SAD programs, we show how to appeal certain consequences of this. If you have been in the United States for less than 2 years and are scheduled for court, the government may try to terminate your removal proceedings to place you in called expedited removal process. Before the hearing, review guidance on how to prepare for ICE enforcement actions and a plan to protect your family. Visit https://immigrantjustice.org/knowyourrights. Share your A hashtag with a loved one, along with the ICE detainee locator link they can use to locate you if you are detained. They will need your A hashtag and birth country. Note, it takes several days for people to appear in ICE's detainee locator database after arrest or transferred to a new detention center. If you have lived in the United States for less than 2 years, ask someone with secure legal status to accompany you to immigration court. If you have lived in the United States for more than 2 years, bring documents to court showing the length of time you have been in the country. For example, United States income tax returns, utility bills, leases, school records, medical records, bank records, or other documents. Know that not attending your hearing could result in an in absentia deportation order. Seek a consultation with a qualified legal immigration counsel or practitioner if you have not already had one. During your hearing, if the government seeks to dismiss or terminate proceedings, object and tell the judge you oppose termination. If the judge terminates your case even after you object, tell the judge you wish to appeal. If you are arrested, if you are afraid of returning to your country, tell ICE about your fear as soon as possible, and repeat it whenever you can. Request a credible fear interview. Do not sign papers you do not understand. Ask for them to be read to you in a language you understand. Who has a right to a hearing? All other non-citizens, including lawful permanent residents and individuals residing in the U.S. but who are undocumented, will have the right to request a court hearing with an immigration judge to apply for relief from removal. Notice to appear, NTA. Here, ICE will serve non-citizens with a charging document that initiates formal removal proceedings called a notice to appear, NTA. This NTA hearing date notice proves oftentimes wrong. The court will issue a new notice of hearing once the court processes the NTA. If the non-citizen is detained, it will take 2 to 4 weeks for the court to schedule their first court hearing. One should check the court portal for updates. As part of their removal case, a non-citizen will typically have several hearings. One asking for more time to find an attorney might result in an immigration judge scheduling you for a new hearing in 2 to 3 weeks to give you a chance to look. Most likely, someone will not be removed at their first court hearing unless the immigrant says they want a removal order. Detained hearings are usually held by video conference. One's immigration and criminal history determines whether one has a right to a bond hearing. Not everyone is eligible. Those not eligible to be released on bond include non-citizens with outstanding removal orders, prior deportations, and convictions for aggravated felonies. Non-citizens having certain criminal convictions require mandatory detention. An immigration judge cannot grant them a bond. Other detained non-citizens in removal proceedings may have the right to request a bond hearing. An immigrant usually can only request one bond hearing. Find counsel to request bond. Otherwise, try to ask for more time at the first court hearing so as to obtain or prepare letters of support, along with other evidence for the bond hearing proceeding. Counsel representation in the immigration court system. No free lawyer. Criminal matters, yes. If no immigration counsel, or board accredited representative, ask the immigration judge for time to find a representative. Search several firms at the same time. Be wary of fraud. In the United States, notaries are not always lawyers. They cannot practice law or appear in immigration court. And check local state bar associations to ascertain whether on a list of currently disciplined immigration practitioners to make sure any counsel hired remains in good standing.